Welcome once again to Lehto's Law. Here's Steve Lehto.
Amy sent me a story, and this is the kind of thing where you look at it and go, okay, some people just don't get it. And here are the people who don't get it are judges and lawyers in Mississippi. A man named Marcus Taylor should have been released from prison years ago, primarily due to a mistake that somebody else made. But Mississippi courts refused to let him go. They refused to release him, so he's sitting in prison. So Lily Uzit wrote this from Mississippi Today. The man's been in jail for 10 years, in prison, serving a sentence that should have ended 5 years ago. In 2015, a judge sentenced the husband and father to 15 years in prison for conspiring to sell some controlled substances. But he spent 8 years in jail before anyone realized that the maximum sentence for his crime by law was 5 years. So in May, the Mississippi Court of Appeals recognized that the man was serving a sentence 10 years longer than the legal maximum, but they refused to order his release despite admitting, yeah, it was a mistake. But they say that the problem is the man raised the issue too late. See, there's a rule on the books, and we've got to live or die by that rule. So the man's now 43. He's indicted back in 2014 on 2 counts of conspiracy to sell the stuff and 1 count of business burglary. In February 2015, he took what he thought was an advantageous deal. He pleaded guilty to the first count in exchange for the 2 other counts being dismissed. The plea petition was filled with mistakes, however. It erroneously said the maximum sentence was 20 years, when in reality it was 5 years. And no one in the court, including his lawyer, realized his sentence was 10 years longer than the legal maximum. So he challenged this in 2023 and said he's at least eligible for parole. And the Choctaw County Circuit Court denied his motion because he filed it past the deadline for doing so. And it turns out there's a 3-year deadline to fix a mistake like this. After investigating the issue for over a year, the appellate court ruled this year that the man was indeed serving a sentence 10 years longer than authorized by law, meaning that he should have gotten out no later than 2020. Yet in a 5-5 decision, they say, well, he's got to spend the rest of his time in prison because he didn't file his request in time. And the 5-5 decision is from the Court of Appeals. So the court invoked a ruling by the Mississippi Supreme Court in Howell versus State of Mississippi, which put an end to the fundamental rights exception, which was an exemption to the 3-year time limit to file a post-conviction relief claim made to ensure individuals don't stay unconstitutionally incarcerated. Now, I understand that they need to have rules because you can't have people just constantly filing motions because they're bored. Once you're in prison and you got 10 years to kill, you start filing stuff. So you got to cap it somehow, some way, right? But when somebody points out something that's painfully obvious, you got to say, okay, there should be an exception where there is something extremely egregious. And this is an example of that. The Mississippi Court of Appeals is obligated to follow the Supreme Court precedent, says the professor at the Mississippi College School of Law. He said this is the expected outcome, that they're going to be meritorious claims that are shut down for technical limits. That's why many people, including dissenters, believe it's wrong. So all Mississippians have the right to be free from cruel and unusual punishment, and to incarcerate Taylor beyond the time authorized by law infringes upon that fundamental right, says the judge who wrote the dissenting opinion. So if the result is tied in the Court of Appeals, common practice calls for the court to confirm the original decision. So the man filed a motion for a rehearing, asking the court to reconsider its application of that case, saying his incarceration is clearly depriving him of his constitutional rights, but the Court of Appeals could still refuse to rehear the case. So the man's lawyer now says they're ready to take the case to the Mississippi Supreme Court if it agrees to examine the case. The Supreme Court could clarify how the law could be applied in cases like Taylor's. So I'm assuming the attorney he has now is not the same one he had previously. Just throwing that in there. I do think one has to reinterpret Mississippi Supreme Court precedent to give Mr. Taylor relief, and that's more of a job for the Supreme Court than the Court of Appeals. said the professor. Many hope the man's case and potential release could set a precedent and protect others in the same situation. Mississippi courts have refused to grant relief to incarcerated people serving expired sentences in the past, even before Howell. We could get a clear law in the state of Mississippi that says there are certain rights that are not abridged at any time, and the court can step in and right it, says this man's attorney. So the escalation of the case has led the Capitol Post-Conviction Council to step in. On June 4th, it filed an amicus brief in support of this man's motion. Although the state office normally assists individuals sentenced to death in Mississippi, it has expertise in helping people file post-conviction petitions. Now, the Attorney General's office, which represents the state of Mississippi, opposed the council's intervention, demanding that the court reject its brief. The AG's office argued that the Capitol Post-Convictions Council involvement was neither necessary nor appropriate, and that it had filed its brief too late. Attorney for this man says the Attorney General's office immediate opposition shows a broader pattern of combativeness against defenses at the expense of fairness and justice. This is the kind of case, and there's more to it than that, but this is the kind of case where a judge, an attorney general, a prosecutor, it doesn't matter who, should look at that and go, okay, the guy pled guilty to this. Maximum sentence is this. But all the documentation turned to the court claimed it was this, and he got this. Clearly, this is a mistake. We can rectify that. Let him go. And the idea that there are rules on the books that are so unbreakable that will lead us to insane results, I can't even understand what that's all about. You know, I mean, I've got the blue books behind me. These are the books that contain the laws in the state of Michigan. And most statutes in this type of setting will have a series of things that'll say, you know, here are reasons that we can grant relief. And then there'll be a catch-all that says something to the effect of, or when manifest injustice will result. Now, it's true that there are sometimes deadlines. There are deadlines that'll say you must file your motion by this point in time. And I've seen people miss deadlines in court. It happens all the time. It's one of the most common problems you hear about is somebody missed a deadline. The question is, what happens if you miss a deadline? Does it literally mean you get no relief ever regardless? Or does it mean that the court should just take a long, hard look at what happened and ask itself, what's the harm of disregarding the deadline this time versus, you know, otherwise? And so here, where a guy is in prison simply because a whole bunch of people made mistakes, and it's no mistake of his, you wouldn't expect him to spot mistakes in legal pleadings when he's not an attorney. So what's the harm of letting this guy out now? What would be the harm? You'd say, well, Steve, that would set a bad precedent. A bad precedent? A guy who has served years more than he should have, according to everyone except for the AG, letting him out. Said, are there more people in prison who shouldn't be there? I'm asking it rhetorically because we know there are, but under similar circumstances? I find that hard to believe, but maybe not. But again, there are sentencing guidelines, and if they say this is the max penalty you can get, now you're going to say, but Steve, I've heard of judges going over those guidelines. They can do it, can't they? Yes, they can. And usually to go over a guideline like that, they have to express on the records why they're doing it. So a judge could say sentencing guidelines, and this is in most states, sentencing guidelines say 1 to 10 years. I'm going to give this man 15, but here's why. And you lay out why this case is so egregious and what the guy did is so bad, why he should get more than that. And then, of course, the guy can take it up on appeal and say, hey, he sentenced me over the guidelines. And then a judge will, the appeals court will look at it and go, gee, was that appropriate considering what the judge put in the record? Here, a guy is simply in prison primarily because of what we call Scrivener errors. Simply almost like typographical errors, but mistakes people made writing stuff down. And how they got the wrong numbers out of something, I don't know. But the point is, he should not be in jail. Don't get me wrong. The guy pleaded guilty to a very serious crime, and he should spend some time in prison, which he has done. So there you go. Amy, thanks for sending that from the Associated Press, and Lily Usett wrote that. Marcus Taylor should have been freed years ago, but the Mississippi courts refused to release him, even though everyone acknowledges the mistake. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Every great achievement is but a small peak in the mountain range of contributions.